Hello and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, we'll talk about waivers and what are they, how do they work, when can you use them, why are they needed? Well, if you're trying to apply for a green card to the United States and you have no problems, meaning you have no crimes, you have no fraud, you have no issues entering the U.S., you haven't been here unlawfully present, you're all in all a very good person, you've done nothing in violation of the immigration laws, then this video is probably not for you. However, if you have committed a crime or your spouse or somebody who you know wants to be petitioned for the green card has committed a crime, has been in the U.S. unlawfully, has various medical conditions, might have committed fraud, all kinds of reasons, then it is possible that you might qualify for a waiver. So basically, let me just give you an example. Let's say that you go into a store and you steal something and you get charged with petty theft, okay? Or you get charged with theft, whatever it is. Then, generally speaking, you will be inadmissible to the U.S. So let's say that you marry a U.S. citizen and the U.S. citizen wants to petition you to become a lawful permanent resident. Well, what would happen is, in this particular case, if you do nothing else other than the petition itself, is immigration would basically say, sorry, you're inadmissible because of the crime, and therefore you cannot adjust status or do consulate processing. End of story, okay? And so what a waiver does is there are certain provisions in the law that basically will forgive the ground of inadmissibility. So in this example that I'm telling you, where, for example, someone has a theft crime, there is the possibility to get a waiver, meaning, usually what my firm does, it's attorney cover letter, declarations, affidavits, psychology reports. Basically, if you can show that your spouse or dependent parents, lawful permanent resident or U.S. citizen parents, will suffer extreme hardship if you're not permitted back into the country or not allowed to adjust, then they will basically, they being immigration, will basically say, okay, forget about the crime, we'll let you in. Okay, that's really what a waiver is. Now, the waiver, unlike what many people think, is the much more difficult petition to get approved than the adjustment of the consulate processing itself. So what you want to make sure is that if you're going to have it done, you're going to have it done right. Because I've had some clients come in with a denial, and they said they filed a waiver and it got denied. So I say, well, what did you do? What did you put in the waiver? They go, well, they filled out Form I-601, and they submitted it. And they wrote a little letter saying that their spouse is going to suffer if they don't come back. Well, that's not sufficient, okay? That's sort of like the cover of the book being submitted to immigration and everything in between being left out. So the waiver being approved is immigration law's way of saying we're gonna make it so you still have a chance to come into the U.S. or to adjust status in the U.S. even if you're inadmissible in the first place. And so not all crimes are waivable, but there are a lot of them that are. There's even certain drug crimes that are. So for example, if you have a possession of marijuana under 30 grams, that's waivable. But if you have a possession for cocaine, that's not waivable. There's other issues in other of my videos that, ways to work with that. But, generally crimes of moral character are waivable. Generally theft and burglary type crimes, ones that have a sentence of less than a year, ones that are not aggravated felonies, are waivable. usually fraud type crimes are waivable. If unless you claim to be a U.S. citizen, that's not waivable. But you come in with someone else's green card, that's fraud, and that's waivable. Also, if you've been in the United States illegally for more than a year and you're going to consulate process and you have no way to adjust in the U.S., it's possible to get the waiver of the 3 to 10 year bar. So, what I'm telling you is that if you think that because you committed a crime or fraud, or you did some indiscretion in the past, and you haven't done anything for a long time, and you're thinking because you did that, there's no way you're ever going to be able to adjust or consulate process, you're wrong. There very well might be a way. Now, assuming that you get past the point where you determine there is a way, then a question of the waiver itself. Now, in addition to what I told you I normally prepare, 99% of the time I will refer my clients to a psychologist who will then analyze the U.S. citizen relative, not the person who committed the crime or the fraud. It's the hardship must be shown to the U.S. citizen or lawful permanent resident relative. So then the psychologist will analyze their situation and determine what they may suffer, and will then prepare a report, for example, of all the extreme depression that they would suffer, and possibly suicidal thoughts, and all kinds of things that they may go through if your spouse, for example, is barred from coming into the United States either for life or for 10 years, whatever it happens to be. And then that report can be submitted along with the waiver itself. So, all in all, a lot of people will think that the immigration laws are unforgivable, that they're meant only to allow only the perfect people to come into the United States, and that it doesn't allow for anybody to make any mistakes whatsoever. But that's not the case. Again, the sole purpose of the waiver is to waive or forgive crimes or grounds of inadmissibility. There's even medical grounds of inadmissibility depending what it is that the person has, and there's waivers for that as well. So what you should do is, you should contact a qualified immigration attorney that is familiar with, number one, the grounds of inadmissibility, because if you file, for example, an adjustment, but you're inadmissible, that's a big mistake right there. So you have to know the grounds of inadmissibility in the first place. But assuming that you know the grounds of inadmissibility and you are inadmissible under a certain provision, then you will be able to then determine if a waiver exists. Now, if the waiver exists, then generally you will prepare the waiver along with the adjustment or consulate processing and go from there. Now, I have another video specifically on the new waiver provisions for waivers of the 3 to 10 year bar and how they can be filed stateside or inside the United States while you're waiting to consulate process. So, assuming you get an approved provisional waiver, you won't have to leave the United States for that long once you go to your interview in the foreign country. However, if you are inadmissible on any other ground other than the 3 to 10 year bar for being here unlawfully present, then of course the waiver itself must be filed, assuming your consulate processing, must be filed at the time that you have your interview and cannot be filed stateside here in the United States. And we're talking fraud waivers, criminal waivers, medical waivers, the new stateside waiver provisions, which have not yet been finalized. That again only applies to the waiver of the 3 to 10 year bar. So, we get into the issue of where the waiver is supposed to be filed. With immigration law, that can be somewhat of a difficult thing to know jurisdictionally where you're supposed to do it. But if you do qualify to adjust status in the U.S., then you can file the waiver concurrently with the adjustment, and I would strongly suggest that at the time of the interview you take an attorney with you, because some officers will, the moment they see a crime, boom, they'll deny it. Okay, they won't even look at the waiver. So they have to be made aware that of the eligibility of the waiver and the strength of the waiver itself. And then at the interview, generally speaking, if it's in the U.S., they won't make the decision right then and there. What will happen is they will then pass it to their supervisor. You'll get a decision in the mail at some later point. But if the waiver is denied, you can't adjust. So then you either have to do a motion to reopen or you have to appeal the denial of the waiver itself, which is all the more reason to make sure that the waiver is prepared properly in the first place with as strong of evidence as you can muster, because to go up on appeal is considerably more difficult. And so don't say, well, I'll try it myself, and if it doesn't work, then I'll get a lawyer. That's sort of the backwards way of doing it. You want to make sure that since the door opening for you to get in the U.S. is getting the waiver approved, that's the number one most important thing you want to make sure is done right. Okay, more on the coming videos.